Our series began with the life and untimely death of Sergeant First Class Allison Bailey.
To hear that a former member had died and so soon after getting out of the military remains a shock to the Nevada National Guard, the family, the friends, and so many in the organization.
Allison went from model soldier to being kicked out of the military. She died 6 weeks after she was discharged. You can see the details of her story at ktnv.com/guarding the Guardsmen. Tonight, our coverage continues with a new twist as military legal experts explain how Nevada law leaves those who serve at a disadvantage. When a soldier gets in trouble, discipline may follow, but due process should come first. That's a fundamental right for all of us, a right service members risk their lives to defend.
It is deeply disappointing, and it's quite unconscionable.
Dr. Dwight Sterling is a former JAG officer with the California National Guard, and he teaches law at USC. Allison reached out to him for advice after she was discharged.
When I met with her, she was a broken woman, and she told me over and over again that it was the disgrace and the shame that that took place when the Nevada Guard made accusations and didn't give her a real trial.
After trying to blow the whistle over what she claimed was a bullying and toxic work environment in her unit, Allison found herself under investigation. She was eventually demoted and kicked out with an other than honorable discharge.
It's a situation where the Nevada National Guard can simply predetermine the winner and the loser in a case, and then can write a script that will manipulate the system in a way to get to that outcome.
It was all part of an administrative disciplinary process called an Article 15, which included nearly 24 allegations.
They were the kind of garden variety types of accusations that are frequently made against someone who blows the whistle, claims that they are a bad leader or that they were mean to me. Right? It's this kind of soft claims that are hard to kind of defend against.
Allison's military-assigned attorney, Chris Tinsman, questioned the entire process.
The complaints against Allison were from years past, to the point that there are some statute of limitations questions.
According to Tinsman, Allison wanted to mount a defense but wasn't fully equipped to do so. Nevada law prevents guardsmen from opting for a court-martial in lieu of the Article 15, often referred to as non-judicial punishment.
It's actually beneficial to the member.
Nevada National Guard spokesperson Captain Emerson Marcus.
A court-martial is for felony convictions. This did not rise to the level of a felony conviction.
But in Allison's separation memo, the Guard characterized the charges against her as serious offenses under Nevada law, punishable as a court-martial may direct. Nearly 24 allegations against Allison included engaging in inappropriate relationships with multiple junior soldiers, disobeying orders and regulations, and not showing up for work or showing up late.
I cannot imagine a judge or a jury in the military context convicting her of the charges that she was convicted of kind of by her commander. It would have shocked me.
If she'd had a court-martial, she could have presented evidence like this to a judge and had it entered into the court record. Allison's mother, Felicia, has her daughter's phone, which contains a text conversation between Allison and her supervising major. Both note concerns about a subordinate guardsman Allison later accused of sexual assault. The major writing, "Please be careful. I've been a tad worried about you and him. Don't be alone." 3 months later, it would be this major that Allison tried to initiate an inspector general complaint against.
Without a whistleblower, there is no one to, call out your misconduct.
In 2015, Nevada legislators changed state law to provide all Nevada service members the right to opt for a court-martial.
The objective was to align the Nevada National Guard more with active duty military.
4 years later, the new law was reversed at the request of state military leadership. In 2019, Assembly Bill 37 was passed, striking the right to court-martial out of state law. We asked the Nevada National Guard for an on-camera interview with Adjutant General Andra Berry to explain why they wanted lawmakers to remove the right to court-martial. We also asked the Guard to describe the results since the reversal took effect. The Guard did not provide the general for an interview and did not answer our questions, instead referring us to lawmakers.
I'd like to open up the hearing on Assembly Bill 37.
We obtained video from the Nevada House Subcommittee when the bill was introduced.
The Office of the Military has found that the resources to conduct a court-martial are prohibitive and impracticable.
Not having a process for soldiers to have their day in court is just unacceptable on a constitutional level.
Both Tinsman and Sterling believe the right to court-martial protects soldiers from retaliation by commanders who control the Article 15 process, acting as the proverbial judge, jury, and executioner. 13 Investigates learned National Guard units abide by their home state's set of laws, which don't always line up with the federal law, the Uniform Code of Military Justice. We researched the law across the country and found Nevada is one of only 6 states where service members expressly do not have the right to demand a court-martial. By contrast, at least 17 states give service members the absolute right.
Which is, it's the basis for our justice system as Americans, not even just military justice.
13 states are conditional. In Arkansas and Utah, for example, service members can request a court-martial, but it can be turned down by commanders. In 11 states, they can demand a court-martial only if they're facing jail time or restriction to barracks. The law in the remaining states is neutral. In that case, Dr. Sterling says the default goes to the Uniform Code of Military Justice, which guarantees service members the right to trial.
Due process, at the very most basic sense, is you get your day in court.
Tinsman believes Allison Bailey was denied due process by the Nevada National Guard. In his appeal of her case, he noted that the military violated its own disciplinary policy, writing Allison is charged with a variety of egregious offenses for which she has never been counseled. He also claimed the Guard interviewed less than half the number of witnesses it should have.
There were people who had made a statement to the investigating officer who were excluded. I talked to those people, so I know they exist.
And he wrote in the appeal that some soldiers were told either that their testimony wasn't good enough or were pressured to sign a statement written by the investigating officer. The Nevada National Guard told us Adjutant General Berry denied the appeal based on no new evidence or arguments presented. We reached out to our federal lawmakers about Allison's case, which Senator Jackie Rosen called a tragedy. Rosen has requested that the Inspector General of the Department of Defense open a federal investigation into both SFC Bailey's sexual assault allegations and the process of her discharge to get to the bottom of what happened. A spokesperson for Senator Catherine Cortez Masto said she referred the matter to Governor Lombardo and is also calling on the Office of Inspector General to conduct a review. Darcy Spears, 13 Investigates.